Hi everyone, it's Samantha Graff from the Graff Group, and I am just going to wait for Cheryl to join us, as well as our special guest, real estate lawyer Zachary, and I'm just waiting to see. I do not believe they are up there. Cheryl, 1 second, view request. You went under the wrong one, but that's okay. I'm just gonna let Zachary in.
And
Hold
then
on.
to the Graff Group.
Doesn't matter. Don't worry about it. You
Want
did
me to
not.
go to the Graff Girls?
You're under Cheryl Graff, just so you know.
Oh,
Hi, Zachary. How
I'll
are you?
go out.
Good, how are you?
Okay, Cheryl. Yeah, go out and come back in on the Graff
How do
group. Or
can
actually,
you?
it doesn't matter. Don't worry about it because I'm gonna do it as a collaboration afterwards. So don't worry about it. It's
Sorry.
all good. It's all good. How are you?
I'm good. How are you guys doing?
Excellent. Thank you for joining us. We're going to chat with Zachary today about status certificates, the importance of them, what a lawyer does for you, how they affect your agreement of purchase and sale. But before we jump into that, let's just get a little bit about Zachary. So Zachary Jorna, is it Zach or Zachary?
Either one's good.
Okay. I know everyone always asks me, Sam, Sammy, Samantha. I'm like, whatever. So I just wanted to get a little bit about your journey through the real estate industry and into your law practice.
Yeah, so I actually got my real estate license back in 2016. I worked as an agent and a property manager in Niagara and then in London while I was completing law school. I then moved to Toronto in 2021 and started my own law practice exclusively on real estate. So basically, I used that working experience on the other side, the sales and management, to build the type of practice that I wanted to see.
And that was one of my attractions when I started reading Zachary's emails to the realtors on different topics related to real estate law. And I just saw that connection and understanding from a realtor's point of view. And that's where his articles were pretty much written from. And so he just really got it, and it resonated with me, which is why I reached out to connect with Zachary. And I think that knowledge of actually working in the field of real estate is very beneficial to your real estate law practice as well as to your clients, which could be our clients too, shared clients.
Absolutely.
So let's jump into our topic of status certificates. For those that do not know what a status certificate is, because they really only come into play when you are purchasing a condo townhome or a condo apartment condominium. So there's sort of I'll let Zachary get into the details on it, but they're basically the checkup on the building itself, the reserve fund. And Zachary, I'm going to give the floor to you to go into a little more detail on that.
Sure. So the condo status certificate is essentially a group of documents that provides information about the financial and legal status as well as the overall health of the condominium corporation. So it offers buyers an opportunity to review, the critical information about the unit and corporation beforehand before actually completing a purchase. So things we find in the status certificates can be things like the legal descriptions and any potential errors, special assessment information, financial deficiencies, legal issues, all factors that can impact the buyer's decision. So on most deals, when it comes to a condominium, there's usually a condition on a status certificate review by a lawyer. And that's where we go through essentially a checklist through all these documents to then provide information back to the buyer on whether or not they should proceed with purchasing.
Okay.
And so, oh, great. Go ahead, Cheryl.
Okay, what I wanted to ask you is sometimes you'll come across in the status certificate that there's a lawsuit from like way back when,
Mm-hmm.
and you should lawyer, like, what is your take on that?
Yeah, so part of our job is to assess what that litigation risk actually is. And so one of the ways we do that is to determine first and foremost whether that's covered under insurance. So a lot of things such as slip and falls, those will fall under covered insurance by the condo corporation. So your total risk is maybe the premium going up eventually if there's eventually a claim filed under it. Now, there are some things more towards the building and construction end where litigation, if we determine that there is a suit against the corporation that's substantial, then it comes down to whether you're the percentage of ownership you have, so each unit is allocated a certain percentage, then we can identify your potential liability if that claim is ever paid out.
Okay, and also if there's an assessment registered against it and they say that you have 4 years to pay the assessment, what do you find the seller will or will not do to help in the sale?
So a lot of that comes down to how the agreement of purchase and sale is structured. So I always advise my agents to make sure that that's something you're dealing with from either end of the transaction to make sure, especially time in between when the agreement is signed and the closing, sometimes, you know, special assessments pop up then, and then it becomes a question, well, whose responsibility is this now? Typically, it falls under what the special assessment was for. So if it's for work that was completed that was enjoyed previously by the seller, there may be more of an argument that the seller is responsible. If it's for future things, there may be more of an argument that the buyer coming in is responsible. But again, the best practice is to include stipulations inside the agreement of purchase and sale of when the cutoff for special assessment should be and who should be responsible for those payments.
And if that assessment comes in after you've firmed up your deal, let's say, but it's occurred in the time between the firm deal and the deal actually closing, what I would assume would be your best ethical practice would be to create an amendment, like an agreed upon clause that would act as an amendment as part of your agreement of purchase and sale. That both sign off on.
Okay, but usually, Sam, there is a clause in there that says that if they're aware of anything, then they would have to, so the wording would have to be that between the firm deal and the
Right.
say all of a sudden there's, you know, a general meeting in June for argument's sake, and your closing is in August, and you knew nothing about anything, an assessment, and they bring it on you. So I guess that clause has to be tightened up, really, to say that between, as you said, the firm deal and because otherwise the best of their knowledge is the way that we write it. So the wording needs to be changed.
Definitely. And that's a good point, Cheryl. At that point, when you've set up the agreement and it's become firm, that's everybody's understanding was there was no special assessment.
Right.
So in that example, if something comes up after the fact, there could be an argument that that should be on the buyer because at that time the seller made the agreement and that was what their information showed.
So what wording should be added to that typical clause that says to the best of the seller's knowledge?
So what we can do in a clause is essentially stipulate a date in which any special assessment that comes after the fact is either the responsibility of the buyers or sellers.
After the agreed upon purchases, agreement of purchase and sale, dated blank, right?
Exactly.
Yeah, that makes the most sense. It's actually a very valid point, because especially now where people's closing dates can be longer because they want to buy before selling, if they're in that position. So you actually want to be clear on something like that, if on any type of condo purchase.
Well,
Absolutely.
well, especially in an older building where all of a sudden you could have a huge rain
100%.
and, rain comes in and the windows need to be changed or a door or roof or something.
But I would think also in a new building that could be a possibility too, because they didn't anticipate something, right? So I think it could. I mean, look, it's important every step of the way, obviously, but um, that new build, you never know what kind of lawsuit can come up against them because of timing, because of the way, we know this from a past client, like they bought something from Blueprints and it was completely wrong. Like the whole unit, it was wrong. Like it wasn't what they said it was going to be. It wasn't the square footage. It wasn't the layout. Like they bought furniture based on this. It's crazy.
Yeah.
Yeah.
So,
What other,
good things happen.
Zachary, what other points would you say are very important that you point out to the buyer when you're reviewing this
Uh,
status certificate?
Chattels,
yeah.
chattels
Great
included.
question. A big thing is what's included in the maintenance fee. Because I mean, the listing usually shows that, but it's always important to confirm that the declarations and the bylaws reflect what the listing says. Because usually the buyer goes off of what was shown on the listing or the MLS listing. But as we know, that doesn't form part of the agreement. So sometimes people go in assuming that, for example, water's covered under the maintenance fees, which it commonly is, or something like hydro, and then to later find out that they're actually paying this on top. So always confirming what that is. A big thing we're also doing is the reserve fund. So we're verifying that a reserve fund study was done within 3 years, which is the legislated time period. And then we're making sure that the condo corporation is implementing the plan that was set out in the reserve fund study. And then we're noting any potential changes. So usually a condo status certificate will show the percentage change in allocation that's going towards the reserve fund. So some people read this as, oh, the condo fee is going up by X%, but typically that means the allocation of your condo fee that's a reserve fund, that percentage is going up. So that doesn't mean the entire fee is going up by 10%, but the amount out of the common fee that is allocated to reserve fund is increasing by 10%. So the actual effect will be slightly lower.
Okay, because a lot of people look at it, like you say, the maintenance fee as the whole, amount. But when you talk about a reserve fund, they don't really understand that part of your monthly maintenance goes towards the reserve fund, and the other part goes to taking care of
Expenses, basically.
takes care of the building, and the other part is your general expenses. So salaries and different things like that.
Yeah,
So,
a good way to look at it is short-term versus long-term maintenance. So, there's a chunk that goes towards the ongoing maintenance. So, like you said, cleaning, administration, having somebody at the front desk if you have that. And then the reserve fund is for capital costs. So, replacing utilities and services, or like replacing balconies, things like that.
right.
Sometimes the maintenance fee also incorporates a rental price of a parking spot. So, and maybe actually talking about parking spots, maybe that's something also to address and clarify for anyone watching, is that there's something called exclusive ownership. Or like, I don't even know if exclusive is considered ownership because it's exclusive use
Right.
versus
Ownership.
owned. Yeah, so maybe you want to share your knowledge on the difference between the two for everyone, because I think that's something people don't usually know or understand very well.
Sure. So we're always looking first and foremost at the legal description. So we verify the unit is the same that's actually on the plan of the condominium. Once we do that, we're looking at whether there's additional deeds. So the two common ones are a locker and a parking space.
Mm-hmm.
So in both these situations, they can either be deeded, so they actually are transferred the same way the property or unit is transferred. So we have its own separate deed, and we just carry that through with the transaction. The other way, like Samantha noted, is exclusive use. So this means as the owner of that unit, through the bylaws, you're given exclusive use to utilize either the parking space or the locker. So it's good right off the bat to understand whether these are owned or whether these are exclusive use. Because if they're owned, for example, you're able to sell that and you have more rights and what you can do with those assets.
Do you feel that one? Okay, so you just acknowledge that ownership. Obviously, you have the right to sell it, as you said. So there is an advantage to that. But I don't have a problem personally. It's just my opinion. When it says exclusive use, do you see any reason why somebody would not want to buy a unit that says exclusive use?
As long as there's stability in the condo corporation, that's not really an issue. Um, so I don't have a problem with exclusive use either. It's just always good to know whether you actually have an owned parking space
Right.
or that's you just have a right to use one.
Yeah, and just so everyone knows, just in case you're not familiar with the term that Zachary used, deeded. Deeded means to own, just in case anybody. Sometimes we just assume people know our language and they don't, so I just want people to be aware of that.
But is there ever a case in exclusive use that, say, a building has 45 units, for example, and there are like not enough parking spots, and because they want to add, are they ever able to take it away from the owner, that exclusive use of the parking spot?
It's a good question. I haven't seen in my experience any situation where they have. Off the top of my head, I would imagine they would need to amend the bylaws or the declarations to actually be able to go in and change the structure of how the condo corporation operates. Um, it's a very good question, though, and it might be a good research topic.
Mhm.
Interested to know because sometimes in certain buildings they have a lack of parking
Parking.
spots,
Yeah.
and many people have two cars and they want the two-car parking, and they can only get one and it's exclusive use. So I was wondering whether the corporation could take away, if somebody had 3 spots, for example, could they take one of those spots and allocate it and say, you only have 2 now, even though they bought it with 3? Would they be able to take that one away and give it to someone else who has only 1 parking spot?
Yeah, so I mean, theoretically, there may be an avenue. I can't imagine it would be easy. And where that can happen. But obviously, that goes back to the advantages of having deeded or owned parking
Exactly.
versus that exclusive use.
Right.
So
Yeah.
yeah, theoretically, there is an advantage to having that because we get into property rights once it's owned, and there's a lot stronger bond versus declarations and bylaws through a corporation that could ultimately be amended.
So
It's
it would
sorry.
be quite complicated. They would have to have, would the board of directors have to go to the general public, get that done, or can they change that?
Sorry, you cut out a little bit there.
Yeah,
Sorry,
you're.
would the board be able to just amend the declaration, or would it have to go to the vote of the owners, change something like that?
That I'm not completely sure. So there would have to be some sort of vote. I don't know at which level in terms of that's brought to the condo corporation.
So,
No.
so if you were in a position where, and I think this is where sort of this stemmed from, if we had a client who had two cars, they buy a condo with one car parking. They know that they arrange for a rental through another condo owner. What's important, what we learned through experience, is that if that condo owner does not own the parking spot, if they were to sell their property, the only way that our client who already bought another one, who'd been renting from them for a year, could continue to rent that parking spot would be if they were to sell the parking spot to them or put it into the purchase of agreement and sale on the new owner to rent it, continue renting it out to our client. So this was like a really, like had our offer done, everything, and then we're like, by the way, is the parking spot owned or is it exclusive use? And that was an issue because we couldn't put our offer in because our people absolutely needed two parking spots. And if that owner who was renting the spot to them ever chose to move and decided to sell their parking spot to the new owner, our people wouldn't have another parking spot.
Yeah, so that brings up an interesting issue of even that due diligence check from structuring the agreement of purchase and sale. So, okay, even if there's an owned parking space, is there a rental agreement on the parking space? Have you leased that out to somebody else where there's an enforceable agreement that if you were to start using that, someone might say, hey, I have a lease contract to use that. Now, the good thing is it's obviously they're not as difficult as, say, a residential tenancy agreement where, you know, there's a lot of issues in trying to end a tenancy. If there is a structured term and it's not a month-to-month parking space lease, your damages would essentially be there may be some civil damages, but again, in terms of where that would ultimately get litigated and how much money would actually be involved, it would be interesting to actually see one of those out. You're probably looking at a small claims event there.
Yeah.
Then what would happen if somebody has an exclusive parking spot and they're not using it? Are they legally allowed to rent it out and collect money because they don't own it? The corporation owns it.
Yeah, so I don't see any issue with renting it out. It's still yours to exclusively use. And if you choose to use that by leasing it, I don't see a problem with that.
You can.
Yeah.
Okay.
So again, unless a condo corporation had a specific rule, which they could have implemented through their bylaws that prevents leasing of exclusive use, without anything restricting that, there would be no reason why you couldn't.
Okay. Sometimes people will rent to other people in the building, but the corporation will have a rule saying that they cannot rent it out to an outside owner for security reasons. They don't want that because then
Definitely.
they're walking in the building.
Yeah.
So anyway, I think we went a little off the status certificate.
It's okay. As long as it's valuable information, then I'm always good with it. I always say, let it go organically. So, Zachary, thank you so much for your time. We're going to wrap it up because we know people don't like watching these things too long. The attention span of people these days is very short. So thank you for your knowledge and your experience. We really appreciate it, and your time, of course. And we look forward to chatting with you on a different topic in the future.
I appreciate you guys having me.
And just let people know before we go off, what's the best way for them to reach you?
So I use a LinkedIn account under my name, Zachary Socvio Marandola. That's typically the best, or my website directly, which is socviomarandola.com.
Awesome.
Great.
Thank you so much. Have an awesome Tuesday, everybody, and enjoy the sunshine. See
Bye,
you
guys.
next week. Bye.